everyone for joining us today. I'm Liz Moyo, State Treasurer, and I want to tell you about what you're going to be learning about today, which could end up being the most important conversation of your life. And that's the conversation about your wishes regarding the type of healthcare you want to receive in the case of an emergency. We know that this is a conversation we should have, but too often we find a reason to put it off. And the reality is that anything can happen to anyone at any time, and we may not always be able to speak up for ourselves. We spend our lives planning for everything, but we don't plan to protect and preserve our voices when we're too ill or hospitalized and can no longer speak for ourselves. When our wishes go undocumented, we may end up receiving treatments that do not align with our preferences, and we leave things unclear for those who matter most to us. So, the thought is we should share and document our goals. And why don't we do that for our care with those who matter the most to us and our healthcare providers while we're still able to do so? And we need to begin having these conversations before it's too late. I want to thank the Quality Institute and the New Jersey Division of Pensions and Benefits for providing this vital information around advanced care planning. The Murphy administration has been working hard to control the costs of health benefits for both employees and employers while improving the quality and delivery of services. The new Conversation of Your Life Workplace Wellness Benefit is a great example of this whole of healthcare approach that we're striving to institute for New Jersey's state health benefit program members and your families. So thank you again for participating in this webinar, and I hope you find the information helpful and useful, and I'm sure you will. Thank you.
Thank you for that message, Treasurer Moyo, and thank you for taking the time out of your day to come join us. I hope you have a wonderful afternoon. And I wanted to introduce myself. I am Dappa Wilcox, the Community Coordinator at the New Jersey Healthcare Quality Institute. The Quality Institute is a nonprofit, multi-stakeholder advocate for the safety, quality, and affordability of healthcare for everyone. The Quality Institute oversees a statewide community health initiative called Conversation of Your Life, also known as COIL, which is a program of our Mayor's Wellness Campaign. COIL aims to engage communities and residents in crucial advanced care planning conversations, and we discuss topics like how to communicate your wishes to your loved ones and healthcare providers, hospice and palliative care, and the various advanced directive documents. And our programming is being adapted to various cultures and languages. And as a benefit to you and your families, we're bringing COIL resources and conversations to New Jersey workplaces, as this conversation is important to have at any age and as early as possible. Through the COIL Workplace Wellness Program, you and your family members will receive vital information on the advanced care planning options that are available to you and the education on different types of advanced directive documents. In addition to receiving these resources, we've implemented virtual wellness workshops tailored towards helping you ease the burden of these often difficult conversations. So planning truly has many aspects, from retirement options to financial planning to living wills and the type of care that you want. And we're here to make sure that you're well equipped and prepared. Now, before we begin, I just wanted to cover a couple of housekeeping items. Please know that this webinar is being recorded and a copy will be posted to our website, www.njhcqi.org, later today. All phone lines will be muted throughout the duration of the program to limit background noise. You may ask questions throughout the presentation or at the end by typing into the chat box or the Q&A tab. The topic for today's presentation is workplace wellness and the conversation of your life. And please be advised, it is not the intent of this program or its speakers to provide clinical or legal advice. So today we're honored to have Gerald E. Rothkopf, Esquire of Rothkopf Law Group, and Robert Ruekers, CFA, CRC, Senior Retirement Counselor at the State of New Jersey Retirement Plans for Prudential Retirement, joining us for today's presentation. And afterwards, I'll have time for audience Q&A. And without further ado, I'd like to begin. So Gerald, whenever you're ready, you can begin sharing your screen and we'll start the presentation.
Okay. So let's see. Thank you, Deba. I appreciate that. And let's see where this takes us. I'm going to all right, everyone should be able to, let me just put this in, I guess, slideshow mode. Okay, so my name is Jerry Rothkopf. I'm managing attorney of Rothkopf Law Group. We're an estate planning and elder care law firm. We're based in South and Central New Jersey. And so thank you for your time today, and thank you for everyone for joining us today. What I wanted to touch base on today is advanced care planning, what Deepa and the treasurer already spoke about, and something just simply to keep in mind going forward. First of all, when we talk about planning, this is just one piece of the total plan. So when I meet with clients, in many cases caregiver children, my role is simply put the pieces of a puzzle together. And Robert, the financial advisor, is another piece of that puzzle. So you have put the financial legal piece together, the care piece, and you arrive at a solution. So this is simply just another piece of the puzzle to keep in mind. Now, one thing I would like to start out with, in a more lighthearted note, is that this is confusing stuff. When we look at planning for the retirement, we look at planning for the future. This is complicated stuff. And, you just dealing with Social Security, dealing with Medicare, doing all the questions about what prescription drug plan would be good for us under Medicare can be a nightmare. So this is just a lighthearted note saying, yeah, this is going to give, in many cases, dealing with all these issues can give you a headache. It really does not need to be that complicated. Unfortunately, it is for reasons beyond the scope of this presentation today. But dealing with these issues can be a little nerve-wracking at times, but we'll try to simplify it for you. So typically, when someone comes to me, whether for themselves, for estate planning, or for a loved one, the issues are, that typically 4 questions, so to speak. How can I protect my assets if I become myself or a loved one becomes disabled? 2, if I need care, what are the options for the best quality care, and what's the cost, and what's the best place for me to live or my loved one to live? And 3, who can make important decisions regarding financial and healthcare issues if I am unable to? And lastly, and this is more of the advanced directive or end-of-life decision-making, do I want my life to be extended by some form of artificial life support, even though a medical event has left me in critical condition without any hope for recovery? And we'll talk about that, the issues over the next several minutes.
Hey, Jerry, really quickly, if you could just go to display settings at the top of the screen and hit swap displays.
Oh, I'm sorry, display settings.
No problem.
Is that better?
Perfect. Okay.
Sorry about that.
No problem at all.
Okay. Were you able to see the previous slides or no?
We could see the slides before. Yep.
Okay. All right. Okay. So legal tools for financial and medical decision making. There's really there are a set of legal tools for financial management, and there's a separate set for healthcare. So I'll briefly talk about both, and you need both. So for financial management, what's called durable financial powers of attorney. You sign those documents when you you have capacity before you're any form of cognitive impairment. Joint ownership of assets. You can own an asset with a spouse and own a bank account with a child. That's joint ownership of assets. Living trust. There's such a concept as living trust. I'm sure most of you heard of that concept. What I will tell you, typically in New Jersey, you'll typically hear, I'm sure many of you heard the term revocable living trust. But what I will tell you as to revocable living trust, it's not done, not used a great deal in the state of New Jersey, because probate fees are relatively minimal. Usually a revocable living trust, the benefits is to avoid probate. There are reasons to have a revocable living trust. If you own property in more than one state, is typical. You are a resident of New Jersey, but have maybe a winter home down in Florida. That may be a reason. Or you have a mountain home in the Poconos, the Catskills, since out of state, that may be another reason. But for the most part, revocable living trusts are not used a great deal in the state of New Jersey. Guardianship, that is a court proceeding, and you have a loved one who's declared incapacitated. Representative payee status, that's related to Social Security. And from a healthcare perspective, like a financial power of attorney, but a durable healthcare power of attorney, that's kind of the umbrella. And then we have end of life, a living will or advance directive. We'll touch upon that shortly. A guardianship can be over financial, and of course, it can also be over healthcare. And a post. A post is a separate legal document. That's an acronym. It refers to physician's orders for life-sustaining treatment. In other words, that's an order that your physician signs regarding the end-of-life treatment that you do not wish to have, and you would sign it. And that's separate and apart from a healthcare power of attorney, as well as a living will. And that's, again, it's an acronym, POLST. It's physician's orders for life-sustaining treatment. And you can pull up the form online or talk to your own physician. Why is it important to plan? Well, unfortunately, a decent percentage of the population age 65 and over will enter a nursing home at some point. The cost of care can be quite astronomical. You want to avoid a crisis. You also want to have your legal documents in place to avoid a court ordered guardianship. And you want to plan when it's not a crisis. You want to be able to investigate your options. That's all part of planning ahead. And you want to protect yourself, you want to protect your family, protect your spouse, protect your children. That's all part of planning ahead and not planning when there's a crisis. Specifically related to the documents for financial or even a healthcare power of attorney, you name an agent. In other words, it could be your child, it could be a spouse, it could be a good friend, someone to make decisions. The person that you name shouldn't be taken lightly. You should have significant thought as to who you would like to name. And the agent is what's called a fiduciary, must act in your best interest. And there's a couple types of powers of attorney. It could be a general, meaning it could be over all financial, it can also be over healthcare, or it could be more limited, limited to a real estate transaction, for example. So it depends on what you're trying to achieve as to what type of document you want. Generally, for the most part, you would want a general durable power of attorney. And the law presumes durability. What I mean by that is that the document, when you sign the document, when you're competent, it remains in effect if at some point you are mentally incapacitated, unable to make decisions for yourself. You generally want it effective immediately because it's going to be used in a moment of crisis. And you have to, if the person named as your agent needs to prove incapacity, that could create problems down the road because it may not be that simple to prove incapacity. You need medical evidence to that effect. As to healthcare powers of attorney, once again, you name the agent. The agent makes healthcare decisions when the individual, meaning yourself, can no longer make decisions. And again, like the financial, you want to name someone who you can trust. And understand this: it's not simple. It's not just words. and the treasurer touched upon it. You should have, if you name someone your agent under healthcare power of attorney or under an advance directive, you should talk to your spouse, talk to your child, talk to your good friend, talk to a grandchild. It should be more than just words, as the treasurer alluded to in her opening statement. You should have that conversation to bring those words to life. And for the healthcare power of attorney to be effective, you need the document, and you need to give the document to a attending physician. What should it contain? A healthcare power of attorney may be, which is more of an umbrella over all healthcare decisions, and within that could be the living will or so-called advance directive component as well. And again, it's important to discuss the importance of what those words mean, because it's not simply a form document. Yes, you can check the boxes. I want to withhold life-sustaining treatment. I don't want life-sustaining treatment. But what does that actually mean? What are your values? What are your religious values? What are your personal views regarding end-of-life care? For financial powers of attorney, again, as I mentioned before, you have a general and limited financial power of attorney. I strongly recommend a general because if it's limited, and let's assume, and I deal with a great deal of individuals who need long-term care and clearly have significant multiple chronic healthcare conditions. And if they have a limited financial power of attorney, and let's assume, unfortunately, they're diagnosed with advanced Alzheimer's disease, they probably are not able to sign their new documents at that point in time. So it just creates an extra burden. And we may need to file a guardianship, which I'm going to get to next, because the proper documentation is just not there. So you don't necessarily want to limit the authority of an agent if there's no specific reason to do so, because you may need a guardianship to sell property, to set up a trust as appropriate. When we talk about guardianships versus powers of attorney, we always prefer a guardianship over powers of attorney. I'm sorry, we always prefer powers of attorney over a guardianship, I should say. Why do we prefer powers of attorney? Prefer POAs, as they're called, because it's less onerous. If a guardianship is a legal proceeding, that means that you must follow the court rules. A complaint for guardianship needs to be filed. You have to be named. You have to, if you want to sell your loved one's home, you would then have to go back to the judge in the county in which the guardianship has been established to request the guardianship, to request the sale of the property. You have to file an annual report. It's more expensive. It's burdensome. So sometimes you can't avoid a guardianship, but the easiest way to avoid a guardianship is to have properly executed financial and healthcare powers of attorney when you are competent. In other words, now you want to everyone who is participating in this webinar should have properly drafted financial and healthcare powers of attorney and advance directives in place. And if you don't, I strongly recommend you get them, because it avoids a crisis, and it also avoids a burdensome guardianship proceeding if you are incapacitated in the future, unable to sign documents. Sometimes you can't avoid it. There are situations, even if you have all your documents in place, a guardianship is still potentially needed. Unfortunately, it could be the person you name might be abusing his or her authority. Is the typical situation. Maybe there's you named co-guardians, and unfortunately the co-guardians that you name are in dispute, and therefore There's no one to make a decision independently because both guardians who have equal authority can't agree, I should say. So there are situations that a guardianship sometimes is still necessary. So those are your documents, and in place, your advanced directive or living will, financial healthcare powers of attorney. Everyone needs them. What I want to move to in a bit, you don't necessarily have to plan for this, but it's something I want you to keep in mind. Maybe, unfortunately, you've had, which wouldn't shock me, several of you have had to make end-of-life decisions for a loved one, which is obviously not a pleasant experience, some of which may be related even to COVID, unfortunately. So when we talk about end-of-life planning, please keep in mind that New Jersey, effective over a year and a half ago, on August 1, 2019, medical aid in dying legislation went into effect, commonly referred to as MAID, Medical Aid in Dying Law. It was effective once again on August 1, 2019. And it is an individual, basically a terminally ill, competent person, age 18 or older, with less than 6 months to live, can legally obtain a prescription medication that will end his or her life, and the individual must be able to self-ingest medication. So this was currently recognized in 9 jurisdictions, including the state of New Jersey as of August 1, 2019. And so that medical aid in dying legislation is not suicide or physician-assisted suicide. And on the death certificate, the cause of death is not suicide, specifically on the death certificate. And physicians must inform patients of a range of end-of-life options before giving the individual the prescription for the MAID medication. And I'm not going to go, I can spend 2 hours talking about the content of the legislation, but I just wanted to give you, due to time constraints, simply a brief overview of the process to obtain the medication. So if you meet the other requirements, meaning you're competent and you're over the age of 18, you can request, you can voluntarily request a prescription medication and from your physician. And of course, you must be an end-of-life condition, meaning your life expectancy is less than 6 months. Patient must make a written request to the physician. 2 witnesses would be needed for that. A second physician must confirm the eligibility, and then either physician may refer the patient for a psych consult. And then there's a waiting period. There's a 15-day intervening waiting period. Patient must be able to rescind the request. And as I mentioned briefly, the treating physician must be able to refer to make alternatives. Could be hospice. If there's mental health issues that's potentially interfering in proper decision making, to a mental health care professional potentially. And there are safeguards in place. First of all, for the participating physician, it's purely voluntary, okay? And the physician can opt out for any reason. It could be professional reasons, it could be for religious reasons. The physician can opt out. So your physician doesn't necessarily have to issue a prescription, and the physician can tell you, I don't participate in this law, I would have to refer you to another physician. So understand, it's purely voluntary. And what I will tell you, I just want to one item. It's the most important part is it's there in the right circumstances, and if you as a patient would like more information, I suggest you just read up online. There's some great online resources you can read up on about this law and the process. You must be competent and you must be able to self-ingest and over the age of 18. So in other words, if you have a guardianship or an individual has end-stage Alzheimer's disease or dementia, they would not qualify. Okay, there's other disqualifications and types of individuals that beyond the scope of the presentation due to time constraints, but the law is there, and I want you to be aware of that. So with that, I talked about piece of a puzzle, and our goal, talking about the advanced care planning today, at least briefly, it's one piece of the puzzle, and if it's always important, at retirement, what's your income going to be? What care do you have? Long-term care insurance? What is your fixed income? What is the state pension going to be? What about my retirement benefits? What's my tax situation look like? All of that's important, in addition to, of course, getting you're talking about advanced care planning, getting your legal documents and house in order. So with that, I think we'll take questions at the end, and I'm going to punt it back to Deepa to take over. I'll stop sharing my screen. So thank you for your time today, and I'll be here when Robert is finished for the Q&A session.
Perfect. Thank you so much, Jerry. And Robert, whenever you're ready, you can begin your screen share.
Okay, very good. Thank you, Deepa, and good afternoon, everyone. Thank you to Gerald for a very useful and informative presentation there, as he laid out very well. It's important to make sure your healthcare wishes are laid out, at a time when you're still of sound mind. And we want to make sure that that's the time you're also thinking about what would happen in the worst case scenario if you were to pass away? What would happen to your assets? And Deepa, can you see my slides at this point?
I cannot at the moment.
Oh, okay. Let me just make sure I'm sharing the screen properly. Give me just a moment. Let's see.
Perfect.
Yeah. Okay, great. All right. So as part of the process of thinking about all these things, and of course we know it's not a pleasant subject to be thinking about, but nonetheless very important. So as part of this process, we want you to make sure you have thought about or are thinking about naming your beneficiaries for the assets that you own, to make sure that your loved ones are protected. And aside from your home, which might be the largest asset that you own, many folks or many people have their retirement assets being the next largest asset, and something that can be passed on to loved ones if you were to pass away by naming your beneficiaries. So we'll walk through that process. Just a quick disclaimer that I'm not providing any advice or recommendation as part of this presentation. It's purely for educational purposes. So many of you as state employees are either eligible for or are enrolled in the New Jersey State Employees Deferred Compensation Plan. And for that particular plan, if you were not to name a beneficiary at all, then your default beneficiary would be your estate. And what does that mean exactly? It means that your retirement plan would pass along into your estate along with all of your other assets for which you either cannot or have not named a beneficiary. So that would again include your home, any other assets that you own outright. So if you do not name a beneficiary on things like your retirement plan or your life insurance, they would pass into your estate. And what that means is there would be a legal process for determining who will ultimately receive a portion or all of your assets upon your passing. There would be, again, a legal procedure. Ultimately, a judge decides who would receive the assets, and usually that's determined in terms of who your next of kin is, right? If you're married, more than likely it would be your spouse who would receive those assets. If you are not married but you have children, then those would be the next in line, and so on. The problem with this process is that it can take many months to be completed. And it might take a long time for your loved ones to receive financial assets that they might need a lot sooner to perhaps help with their expenses as a result of you passing away and no longer having the income that you were providing to the family. So for that reason, it is important to name beneficiaries directly, because you bypass that legal process and the funds can be paid out directly to the beneficiaries without delay. You may have other accounts where the default beneficiary, if you do not name one, is your spouse. So that is sometimes the case with certain retirement plans, but for, again, the state deferred compensation plan, it is your estate. So a couple of beneficiary types that you should be familiar with. One is called primary beneficiary. That is essentially the person that is first in line when you pass away, and would be the person to receive the assets in that event. The most common primary beneficiary, especially for married couples, is the spouse, but it typically does not have to be the spouse. It could be anyone, especially again with the deferred compensation plan. It could be anyone of your choosing. And then there's a secondary beneficiary designation, sometimes also called contingent beneficiary. Those would be the backup beneficiaries in case something were to happen to the primary beneficiary. So that's oftentimes for people who are married and have children. Their children are typically the secondary beneficiaries. Again, it could be anyone that you choose, more often than not, but that is a common way of designating your beneficiaries: your spouse as your primary and your children as secondary beneficiaries. So again, some common designations: your surviving spouse, children, or other non-spousal individuals if you're still single or are single, and you could name your parents, you could name brothers or sisters, nieces, nephews, could be even a friend. So it's very much up to you. In addition to individuals, you could also name a trust as a beneficiary, or even a charity. So those are options as well. When it comes to non-spousal beneficiary considerations, again, oftentimes it is a child. If it's not a spouse, these are important things to keep in mind, especially for those who have gotten divorced. There are some stories that we come across as retirement counselors for state employees where a divorced individual ends up passing away, but never updated their beneficiary from their ex-spouse. So in that case, the assets pass on to the ex-spouse because the beneficiary designation held by the financial services institution that holds the account trumps everything. It trumps whatever's in your will or any other legal documents. So that's why it's really, really important to always update your beneficiaries whenever you have a life event. If you have another child that is born, you want to make sure you add that additional child as a beneficiary. Again, if you're divorced and get remarried, you'd want to presumably want to update your beneficiary to include, to replace your ex-spouse with your new spouse. If it's a blended family, again, those are all considerations that you want to make sure that your assets are passed along to the people that you intend to receive them. So a couple of ways to designate children as beneficiaries. And there's really a wrong way to do it and a right way to do it. The scenario on the left where one child, in case of multiple children, is named as the beneficiary with the intention of having that child take care of the rest of the children. It might sound like that would make it easier, right? Maybe it's the oldest child that's maybe even adult already, whereas the others are still minors. You might think, let me just make sure that the oldest child is named as my beneficiary, and then I'll give that child instructions to spread the assets equally among the other children. The problem with that approach is that there's a double taxation that can happen in that sense, because first of all, the child who is named as the only beneficiary will likely have to cash out the account in order to be able to split the proceeds among the other children, right? So that's a taxable event. Then those assets passing on to the other children could create another tax situation for them as well. So instead of doing that, it is definitely much better to just name all the children equally directly. It doesn't even have to be equal. It could be any percentages that you wish, but to make sure that they all receive the assets directly avoids that double taxation scenario. Another thing to keep in mind is if you have children that have their own families, what do you want to happen in those situations? If you have two children and they both have children, in other words, you have grandchildren, and you want to make sure that those grandchildren receive a portion of the assets in case something were to happen to one of your children, if one of them predeceases you and you don't have a chance to update your beneficiaries. The way you can address that is to name your beneficiary and then add the legal term per stirpes after their name. What that does is it will make sure that, again, if one child predeceases you and you pass away, that the portion of the assets that was supposed to go to that child will still flow through to his or her children, or in other words, your grandchildren. If you do not add the term per stirpes, the operating assumption, the default is that everyone is paid out on a per capita basis. And that means it's only the surviving beneficiary that receives any assets. So in the scenario on the left, you can see one of the children has passed away, then you pass away, only the surviving beneficiary receives all of the assets at this point, and the grandchildren from the child that passed away do not receive anything. So this is just another thing to keep in mind, and make sure that you add that term to your beneficiary. You would basically just, again, write it out after their name on your beneficiary form. And this typically requires you to fill out a form to be able to make that designation. It's usually not something that you can do online. So you will have to submit a written form for that. When it comes to minor children, they can be named as beneficiaries. We often get that question, whether it should only be adults that are named as beneficiaries. The answer is no. You can have minor children as your beneficiaries, but you do have to keep in mind that if something were to happen to you while they are still minors, then there would have to be someone named a custodian that would be responsible for handling those assets or making decisions on behalf of the minor until they become of adult age. So that would be something that you could address in your will. Another method would be to use the Uniform Transfer to Minors Act, or UTMA. You can establish an account or have that particular law, take advantage of that law in order to have assets held in the name of a custodian until the child becomes of adult age. Again, it's important to update your beneficiaries as additional children are born. And if you really want to make sure that you have some control over how those assets are paid out to especially minor children, then you could consider using a trust for such a purpose. So using a trust as a beneficiary is definitely an option. I would say that you probably only want to do it when it is necessary. Again, it would be a good situation to use it for minors. Also, perhaps with disabled children, or even if once they become adults, if they're a special needs child, that is also a good situation to use a trust. It allows you to have more control over the assets, right? Over how they are paid out to them over a certain period of time, or, again, whatever wishes that you want to have in place for those. But one thing to keep in mind with trusts is that it does limit how the assets or what the beneficiary can do as far as their options are concerned. If it's an adult or even a minor, and they're named directly as a beneficiary, one of the options potentially is for them to not take the assets paid out to them, but they could potentially have them transferred into what's called an inherited IRA. So it would allow them not to have to take the money and have a taxable event, but allow the assets to continue growing and put off that taxable event. There is a recent law that was passed which took away the ability to have an unlimited amount of time for assets to pass along to the next generation. That used to be called a stretch IRA. So now there is a requirement to pay out proceeds from a beneficiary account over a period of 10 years. So it could be done in 10 equal installments. It could be that 10 years go by and then the entire amount is paid out. But over a 10-year period, those assets have to be paid out. That would be in the case of any adult beneficiary. If it's a minor, then that 10-year period wouldn't start until they become an adult. Another option is to name a charity as a beneficiary. That is definitely something you could do. And one thing to just keep in mind, again, it would require usually a physical form to be filled out. You would have to provide the tax ID for the charity. And you'd want to make sure that the charity is aware that they are named as a beneficiary on your account so that they can use that for their planning. So as far as distribution options are concerned, it could be a lump sum payment, it could be installment payments or partial distributions. Again, it does have to be completed during that 10-year period. And each retirement plan will have more specifics as far as what the beneficiary payout options are. Just one quick note that I wanted to make. We're not just talking about retirement plan assets here. Another very important asset that you might have, and you do have if you're an active state employee, is life insurance. The life insurance payout would go directly to a beneficiary as well, if you have a beneficiary or more beneficiaries named on your life insurance. So think about this not just for any individual life insurance policies that you might have, but also for your group life insurance that you have as part of your benefit package, right? You all will, your beneficiaries would receive some multiple of your salary if you were to pass away while you're an active employee. So you want to make sure that you have beneficiaries named for your group life insurance as well, so that those proceeds can go directly to your loved ones, that there's no delay in having that go into the estate first. And life insurance proceeds are tax-free to the beneficiaries. So that's another important thing to keep in mind. Just a very quick note, something you may want to consider, especially if you've worked at a number of different places and have multiple retirement accounts. You might want to consider consolidating them for a number of different reasons, but one of them could be to make life easier for your beneficiaries, right? Instead of them having to contact 4 or 5 different financial services companies to figure out where these accounts are, and also having to update your beneficiaries for all these accounts whenever you have a life event. By consolidating them, you will make that easier for yourself as well as for your children. And again, there's different triggers for you to update your designations. If you get married, you get divorced, the birth of any child, or the death of a named beneficiary. So just to wrap things up, the process for you to think about is considering who should be your primary and secondary beneficiaries. Review your accounts, update your beneficiaries as needed. Consider consolidating your assets if you have multiple plans that you could combine into 1 or 2 plans just to make life easier for yourself and for your loved ones. Let your beneficiaries know that they are named on your accounts as beneficiaries so that they have awareness. Maybe share with them where that information can be found. You can contact, in the case of your state retirement plans, your prudential counselor for assistance in updating your beneficiary online or through a paper form. And then consider your other group benefits and individual accounts, as I mentioned, your group life insurance, individual life insurance, any other retirement plans or IRAs that you may have. And then last but not least, seek the advice of a lawyer or a tax advisor, especially when it comes to establishing a trust or whatever your options may be when it comes to making sure that your loved ones are taken care of in the event of your passing. So that concludes my remarks. I think we have a little bit of time left for a Q&A. So I'll turn it back over to Dappa.
Thank you. And give me one moment. Perfect. So I wanted to say thank you to both Jerry and Bob for all of that helpful information. And before I open it up for audience questions, I just wanted to give a quick reminder that this webinar will be available on the COIL webpage so that you can review the information that you may have missed, or you can share it with your friends, family members, or colleagues. And on our website, we have plenty of webinars with various topics like support for caregivers, advanced care planning for patients with dementia and Alzheimer's, having a conversation with veterans, and many more that we didn't get to dig into today, but it may be of interest to you and your family members. And we also encourage you to take a visit to our website and look at the resources to help you and your loved ones start thinking about your wishes and strategies for how you can comfortably approach these conversations with one another and your healthcare providers. So at this moment, if you have any questions for either of our speakers, please feel free to type them into the chat box or the Q&A section, and I'll get to as many as we can before the end of this hour. So first, I just wanted to ask one question that I see quite often is what's the difference between a living will and a healthcare power of attorney? And do I need both documents? I guess, Jerry, if you would
Sure.
like to address this.
Generally, you do need both documents. Healthcare power of attorney, think of it as an umbrella policy, so to speak. It's all encompassing from the moment you sign it until death. However, a living will, commonly referred to as an advance directive, is limited to end of life. Your life expectancy, for example, is 6 months or less. So so you do need both. For example, not all situations where you're unable to make your healthcare decisions for you is end of life. For example, someone suffered a stroke and they're hospitalized, and they're not necessarily on their deathbed, but they're incapacitated. Maybe if not mentally, I should say, but physically, they can't go to the bank. Maybe they have what's called aphasia, meaning unable to speak. So they can't contact their financial advisor to access their retirement plan, or talk to a pension benefits counselor, or talk to HR or from their employer or such like that. So it's not necessarily end of life. So you need both, more of a general blanket healthcare power of attorney, and then more limited end of life. So your healthcare wishes will govern, especially related to end of life.
Thank you. And we have another right here. This one's for you, Bob. What happens if there's no beneficiary named on an account or a policy?
Right. So I did cover that in the case of, for instance, the state deferred compensation plan, where it would revert to your estate, right? So no beneficiary named for your deferred compensation plan. The assets would transfer into your estate and then would go through a legal process to determine who those assets should be paid out to. Again, that can take a long time, sometimes many months, and it may not necessarily end up being allocated in the way that you wish for it to be done. Some other assets do have it automatically go to the spouse if you're married and your spouse is living, but that's not the case in all instances. So your best bet is definitely to name a beneficiary and not just automatically assume that it'll be taken care of, if you don't do anything.
Thank you. And I know you had covered naming children, like your children, as beneficiaries, but what if your child's a minor? Can a minor be named as a beneficiary?
Yep, absolutely. I mentioned that too. And the only thing you really would want to make sure is that you have addressed who would be your child's custodian, right? In the event of your passing. Of course, that in the case of minor children, that would include, how they're going to be taken care of and by whom. But with respect to, the assets that you are passing along to your minor children, you would want to have someone in place, a custodian, to be able to make those decisions for them, right? In terms of, do they have any particular need for immediate funds to come to them? In which case there could be a payout of some sort. If there is no immediate need, then the custodian might help with transferring those assets to a beneficiary IRA, so that they can continue to be invested and continue to grow for the minor child until they turn into an adult, and then that 10-year process or 10-year window opens for them to eventually have to take those assets and get them paid out.
Perfect. Thank you. And we have time for one or two more. I guess either of you can answer this one. So what have the implications of COVID-19 taught us about the importance of documenting your end-of-life care wishes?
I'll take it at least from the healthcare side. It shows you that life is precious, certainly. And I'm sure we all know someone. I would bet if I was a betting man, everyone participating in this webinar probably knows someone who died COVID related, at least locally or nationally or internationally for that matter. And it's important to get everything in place. Again, you want to make sure you have everything in place when you're able to do so. And as Robert talked about, make sure you have everyone has a will. You have updated beneficiary designations under your retirement account. You have your life insurance up to date and beneficiaries. If you're divorced, make sure that you don't necessarily name your ex-spouse as beneficiary. Make sure that's been addressed. If it's a second marriage, you want to make sure that you have everything up to date and the way you want it. So it's the sanctity. It really makes us realize really what's important in life, the sanctity of human life, and from a personal perspective, and I'm sure some of you can relate, it's also to reflect on what's really important in life. Maybe I really didn't need to do certain things that I did pre-March of 2020, and whether it's in your personal life or whether you're in your work life or both. So it shows how important it is to make sure everything's in place before a crisis arose. You're not running around for your documents, and so it's certainly changed us. Besides, of course, this type of participation webinar that we're involved in today, it certainly changed us work-related, technology-wise, commuting-wise, and we'll see where it goes from here. But I like to look upon it as that out of any crisis comes some good, and I think some good will come out of it in the long run, and we'll do things that we kind of just put off before and make sure it gets done.
Yeah, well said, Gerald. Not much to add to that, other than just saying that I think many of us have optimism bias, right? We kind of feel like, hey, it's not going to happen to me, or I'll do that another day. I'm fine. I'm perfectly healthy. As I think this past year has proven, things can change on a dime, right? And even before COVID, we know that anything can happen to us on any given day. You can get into an accident. You can, just something unforeseen can happen, and you want to make sure that you have everything in order in the case of something unforeseen happening. So I think this past year has taught us to be prepared and to spend some time thinking about these very important items while you're, again, sound of mind, and also think about your loved ones. Maybe you have older parents that are getting to a point where you want to make sure that everything is in order for them. Have that conversation with them. It's a difficult conversation, but you want to make sure you have it nonetheless.
Agreed. So I just want to say thank you to both our speakers, Gerald and Robert, for taking the time to present today and giving us all of that wonderful information. If there were any questions that we were unable to get to, feel free to reach out to me at dwilcox@njhcqi.org, and I'll touch base with both of our speakers and get all the answers over to you. So once again, thank you both, and thank you all for joining us today. And I hope you all have a wonderful afternoon.
Thank you, everyone. Have a good day.
All right, thank you. Take care.
Take care, everyone.